Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal educational content, and today's the day I earned that subscription. For Great. For today's story, we're covering the ongoing saga of Jussie Smollett. Jussie Smollett, Jussie Smollett, Jussie Smollett, all these names. I have so many tabs with this open. The audio is just coming from everywhere. We'll get it right eventually. Anyways, a guy coming from my phone, a guy coming from my computer, just bleed over everywhere. You know, we're doing it live. Let's try to get this through this. Anyways, we're dealing with Jussie Smollett, the famous French actor who worked on Empire. You'll remember him. He made an allegation that he was attacked at something like 3 in the morning in Chicago on like literally the coldest day of the year, and it was even colder than that because there was a polar vortex that was occurring at the time. So it was really, really cold, really cold. He says he went out of his house at like 3 in the morning to walk down to Subway in order to get a sandwich. And on his way back, he said he was attacked by two white people in MAGA hats who put a noose around his neck, threw bleach on him, and said many racist things. This didn't seem to really work out. And as the police investigated this, it's like, yeah, that's wrong. And then we learned about the Alsadaro brothers, I believe their name is, who aren't so much white as from Nigeria. His trainers, who he paid by check, which was a nice touch, by the way, paying them by check. He paid them by check in order to conduct the assault on him, apparently as a bid to get fame and or sympathy, also potentially as a move to have him his pay increased on a show. Also, this is potentially not the first time that Jussie did this. He was also noted that there was a prior incident where a piece of threatening mail came to him and made all sorts of allegations, and we seem to think maybe that was fake too. You'll remember that. He was convicted by a jury and I think spent something like 6 days of his about 180-day sentence in jail. And then he appealed, principally on double jeopardy grounds, because he had reached a corrupt settlement with the prosecutor Fox, where he agreed to, pay a very nominal damage and undergo some community service or something, and it would all go away. They filed a null pros, say we're not going to prosecute this, and then a different prosecutor was appointed and prosecuted me. Went to jail. I was like, you can't do this to me twice. But yeah, I had my doubts because double jeopardy doesn't seem like the right thing, because jeopardy typically attaches when the jury is sworn in, and of course we were nowhere even close to that at the time that he made this corrupt bargain. So I was like, okay, not so much with the double jeopardy for you. But we have an opinion today from the Court of Appeals of Illinois who says not so much for you. Please go back to jail and serve out, the remaining 174 days or whatever it is of your sentence. Fun and exciting. So let's read their decision and understand a little bit about the law as it applies in Illinois. Let's get started with this. All right. A grand jury had returned an indictment against Jussie on 16 counts of felony disorderly conduct stemming from his 16 false reports to Chicago police officers that he had been the victim of a racist and homophobic attack near downtown Chicago on the coldest night of the year, which was even colder than you'd expect because of the polar vortex and so forth. Thereafter, the Cook County State's Attorney Office, through Prosecutor Fox, null prossed the case against him. No prosecution. However, after the appointment of a special prosecutor, because we're like, this is some bullshit, a special grand jury, which typically means they're just called for that specific purpose, as opposed to just a general grand jury. Grand juries can sit around for a long period of time and they tend to hear lots of cases. So they're typically called for months of service at a time, and they hear evidence relating to a whole bunch of cases, but of course your mileage may vary depending on your state. So special grand jury indicates to my mind that means they were called specifically for this. Okay. So they re-indicted Smollett on 6 counts of felony disorderly conduct based on the same allegations. Following a jury trial, he's found guilty of 5 of the counts and sentenced to 30 months probation, with the first 150 days to be served in jail. He was also ordered to pay a $25,000 fine and $120,000 of restitution to the city of Chicago. On appeal, he challenges virtually every aspect of the prosecution for the following reasons we affirm. Fantastic. Let's learn more. In February 2019, there was a criminal complaint against him for felony disorderly conduct. He turned himself into Chicago police the next day and posted his bond. Thereafter, the grand jury returned a true indictment against him for the felony conduct, and they filed a 16-count indictment. This is his first prosecution. The indictment alleged that Smollett filed false reports to the Chicago police that he'd been physically attacked by 2 white men shouting racist and homophobic slurs. He pled not guilty. On March the 26th, so basically just a month later, the state advanced a scheduled status hearing, so it wasn't on the docket at that point, so they asked for it to be moved up. And they filed an oral motion to non-pros. So 1 month later, after the grand jury said, hey, how about the 16 felonies? 1 month later, Prosecutor Fox, the chief prosecutor of the jurisdiction, who has some ties to Smollett and others, said, okay, we don't want to prosecute him anymore. In the court, the assistant state attorney said, after reviewing the facts and circumstances of the case, including Smollett's volunteer service in the community, an agreement to forfeit his bond to the city, the state's motion in regard to the indictment is to null pros. We believe the outcome is just disposition and appropriate resolution of the case. Fun. The trial court granted the motion or the clerk of court to release him back on bond. In April 2019, so a month later still, a retired appellate court judge filed a pro se petition to appoint a special prosecutor to investigate and prosecute the people of the state of Illinois versus Jussie. So some former appellate judge was like, this doesn't sit right by me. I'd like someone to look into it. The petition was docketed and subsequently assigned to be heard by Judge Michael Tuman. In June of 2019, over the objection of the prosecutor's office, the judge ordered a special prosecutor be appointed to conduct an independent investigation of the actions of any person or office involved in all aspects of the case. And if reasonable grounds exist to prosecute Smollett, in the interest of justice, the special prosecutor may take such action as may be appropriate to effectuate that result. So that's pretty cool. I didn't really know that was possible, but apparently in Illinois that's possible. Apparently, basically a random guy at this point, because he's no longer an appellate judge, apparently a random guy can file a motion and be like, hey, judge, I know you never heard of me, but would you like to appoint a special prosecutor to prosecute this case? And apparently that's an option in Illinois because they took the case and gave him what he wants. So that's fun. The judge further found that unprecedented irregularities identifying the case award the independent prosecutor to restore public confidence in the integrity. Yeah, there were many problems, including did she recuse herself or didn't? Because, for example, Prosecutor Fox, head of the office, said she recused herself at one point, but the office wasn't recused because, as you saw just now, it was one of her assistant prosecutors that went into court and said, we want to dismiss this, which isn't how that works, right? If the chief prosecutor is conflicted out, that conflicts everyone in the office because it's the chief prosecutor, right? If it's some lesser prosecutor in the office who's conflicted out, then, we might be able to reassign it to someone else in the office. But when it's the chief prosecutor, they can't do the case, so no one on their staff can, because obviously everyone on her staff reports to her. So there's no way to recuse her. So you'd have to send this. Typically, what you would do in such a situation is you would send it to the neighboring county and you'd ask them to help out. That's how we typically go about it. So that was an issue. And then her ties to Jussie and other people was also it. And also the crime was obviously incredibly well documented. And also the confession of the brothers and all other sorts of problems. There were many irregularities in this case, so I certainly don't blame the judge. Okay. The following month, he filed several motions before Jussie Smollett filed several motions before the judge, including a motion for reconsideration of the appointment order and a motion to intervene. In denying the motion to intervene, the judge clarified the order only enables a special prosecutor to conduct the independent investigation, and a re-prosecution isn't ordered, but may occur if additional considerations are met, for example, reasonable grounds. So he didn't order the special prosecutor to prosecute, which would be one hell of an order. It's like, could you just look into it and make sure it's clean? The judge also emphasized the order was not an interim order. He did not appeal that order. In August of that year, the judge appointed Dan Webb as the special prosecutor to conduct the independent investigation of the actions of any person or office involved in aspects of the case. Again, your law is going to vary as to who gets to appoint a special prosecutor. But the fact that a judge is doing this isn't inherently absurd. Some states roll that way. Some states it would be done by the attorney general. In other states, there's different mechanisms for this. So apparently in Illinois, the way they roll about this is that the judge can do this, which, okay, fair. That's how Illinois rolls. And if reasonable grounds exist to prosecute in the interest of justice, they can take the actions that might be necessary to effectuate the result. In February of 2020, the special grand jury, after the investigation by the new special prosecutor, indicted Jussie on 6 counts of felony disorderly conduct for his false reports. Later that month, he was arraigned and pleaded not guilty. On the same day, he filed an emergency motion for a supervisory order in the Illinois Supreme Court asking the court to vacate the order, appointing Webb as a special prosecutor. Illinois Supreme Court said no. Smollett then filed several motions in the trial court seeking dismissal of the second indictment on various grounds, including alleged violations of double jeopardy principles, which obviously is the most notable. And in an earlier stream today, we were talking about the importance of double jeopardy and how sacrosanct it is. But as I pointed out a little bit earlier in the stream, jeopardy typically applies when in a jury trial when the jury is sworn in. And obviously that hadn't happened. The indictment was only a month old. We're nowhere even remotely close to a jury being assembled, let alone sworn in. So the legal result should be no double jeopardy because there was no legal jeopardy. And the settlement, such as it was, is corrupt and all the rest of it. So yeah, but he filed that, challenging the validity of the special prosecutor's appointment and asserting a violation of the agreement to dismiss his original case, all of which were subsequently denied. Yep. The brothers who were involved in the attack, whose names I'll screw up, but we'll try, the Yosarondo brothers, how about that? The 2 brothers alleged to have assisted in the attack by, confessing to it and saying we did it and presenting the check that Jussie presented them to pay them, because Jussie, genius to the cause, paid them by check for the fake crime. Moved to intervene and disqualify the Smollett's lead defense attorney from representing Smollett because he previously consulted with them regarding the facts of the case. Following the evidentiary hearing, the trial court ruled the attorney could appear as counsel. So are they conflicted out? No, we're fine with that. Fine. But other members of the defense team would be required to cross-examine the family at trial. Fine. So we don't want to conflict them out, but because this guy knows too much, he can't conduct the cross-examination of the brothers. Fine, no problem. Smollett also moved to obtain notes from the meeting of the Office of Special Prosecutor he had with the brothers, but the court denied, which makes sense because it goes to internal work products. So yeah, that doesn't make sense. The evidence introduced at trial established that in the early morning hours of January 29th, 2019, when it was bitter cold in Chicago, the windy city, and there was a polar vortex, and he left his house to walk to a Subway to get food. The Chicago police officers responded to Smollett's high-rise condominium near downtown Chicago to investigate the report from Smollett's creative manager that Smollett had been the victim of a crime. He called himself the creative manager. That's a nice touch. Smollett reported to the officers that two unknown individuals, white guys, yelling racist and homophobic slurs have physically attacked him. While receiving medical treatment at Northwestern Memorial Hospital, Smollett repeated the same allegations to other detectives. The police later identified two suspects matching the description of alleged offenders from a security video footage showing two suspects exiting an Uber, entering a taxi cab and arriving near the crime scene moments before the alleged attack. The Uber records confirmed that the brothers had ordered the Uber observed in the vehicle. The brothers had ordered the Uber that was observed in the video. After being arrested February 13th, the brothers admitted to staging the attack against Jussie at his request. When the police re-interviewed Smollett the next day, he reiterated the same allegations as before. At trial, the brothers both testified that they had participated in the staged hate crime orchestrated by Jussie. They testified that Jussie had staged the attack because he was unhappy that his television studio was not taking a hate mail that he had received seriously, which incidentally I'm pretty inclined to believe was also faked. Other evidence introduced at trial between the messages for the brothers, cell phone data, video evidence, receipts used for items at the attack because they bought the items they used, and those items were also caught, their purchases were caught on camera, and the check itself from Smollett made out to the brothers. So we have pretty decent evidence that this was staged because of all those things. Smollett testified in his own defense he was attacked by two offenders in January 2019. He denied he paid the brothers to help him stage the crime. Other witnesses called by Smollett include his former manager, who had been on the phone with Smollett at the time the alleged attack occurred, and with Dr. Torelli, a Northwestern Memorial Hospital physician who had treated Smollett for his head injuries after the attack. Great. The jury, considering all this evidence and weighing it as the jury does, found him guilty of 5 counts of felony disorder. Fun and exciting. After the sentencing hearing, the trial court sentenced him to 30 months probation, with the first 150 days of the sentence to be served in the Cook County Jail, or to pay the $25,000 fine and $120,000 in restitution for the loss of all the police time. Smollett contends that the statutory authority was lacking for appointment of a special prosecutor. The appointment order was vague and overbroad. No. The appointment was not statutorily allowed, and the circuit court erred in denying defense counsel motion for a substitution of judge. The prosecutor responds the court lacks jurisdiction over these issues because they didn't arise in the case over appeal. I mean, he did have the opportunity to appeal those issues, and he didn't. So there is a law of the case problem, as we've discussed, right? Because he didn't appeal those issues, he's sort of bound by that because that's been decided. That's fun. The petition seeking appointment of the special prosecutor was filed in April 2019. In June of 2019, the judge granted the petition to appoint special prosecutor. Smollett did not appeal that order. You use it or you lose it. You lose it, you use it, or you lose it, my friends. On July the 19th of 2019, Smollett moved to intervene in the case, arguing pursuant to law that he was a non-party directly affected by the proceedings. He also moved for reconsideration of the order, appointing the special prosecutor and for substitution of a judge. In denying the motion to intervene, the judge stated the appointment order was not an interim order. The other motions were denied. He didn't appeal. In August 2019, the judge appointed Webb as a special prosecutor and ordered him to conduct an independent investigation. The judge also ordered Webb to prosecute Smollett if there were reasonable grounds and didn't appeal that order. You use it or you lose it, right? He didn't appeal it. On February, so he probably didn't preserve his issues. That's fun. On February 11th of 2020, the special grand jury returned the indictment, charging him with 6 counts. In February 24, he pled guilty. That same day, he filed an emergency motion in Illinois Supreme Court seeking a supervisory order, which was denied. He filed for writ of mandamus. Hey, Supreme Court, can you fix my problem? Lol, no. In July of 2020, Smollett moved to dismiss the second indictment, alleging invalid appointment of the prosecutor. In denying the motion, the case filed in 2019 was a totally different case number, a totally different proceeding. I don't see how I'd have any authority at this level to revisit the ruling, so it's denied. Trial court not having it. Similarly, this court has no authority to review orders in the case because an appeal as a continuation of the circuit court proceeding. The notice of appeal cannot vest jurisdiction in this court over an order entered in a different proceeding. Law of the case, my friend. Law of the case. It's basically res judicata as it applies to the case. Res judicata, we're typically talking about different cases. Law of the case is just res judicata as it applies to this thing. A thing decided. So a thing decided. Once an issue, whatever it might be, is final. Once that issue is final, it's final. You don't get to revisit it, right? Because courts often deal with things in parts. You know, they often make rulings in part. And if you appeal those issues, and that's final, and you don't appeal or whatever, those are final. So the law of the case. So what the court is saying is, hey, look, there was this order from the judge appointing the special prosecutor. There was a hearing. You knew about it, by the way, because you filed the motion to intervene. And the judge said, you know, screw you, I'm going to do it anyway. And then you didn't appeal. You didn't appeal that order. So that order is now effectively over because of you, right? So the appeal court is just saying law of the case, right? This court can't review that decision by that judge because that decision by that judge had its own appellate process, which has already been resolved. And we don't revisit it because law of the case. So go away. Yeah. Okay. Unless there's properly filed notice of appeal, a reviewing court has no jurisdiction over the appeal and is obliged to dismiss it. Facts. A notice of appeal confers jurisdiction on the court of review to consider only the judgments or part thereof specified in the notice of appeal. Further facts. And once that's decided, it's decided. Smollett failed to file a timely notice of appeal relating to that order. As the filing of the notice of appeal is jurisdictional, it goes to the authority of the court to hear it. Right? The court doesn't have jurisdiction to hear the case unless, you ask. This court also lacks jurisdiction, which is in a different case. Because of course they do. So we're not going to relitigate that. Get wrecked. Smollett's argument he was unable to appeal orders entered that case because he was not a party without merit. The Illinois Supreme Court has been construed to allow non-parties to appeal so long as the non-party has a direct, immediate, and substantial interest in the subject matter with which he's be prejudiced. Yeah, obviously, right? If you belong as a party in the case and the judge says, I'm not going to enter you as a party, that's an adverse decision to you. Obviously, you can appeal. Of course you can appeal. The very nature of the appeal is, I'm not a party to the case, and I should be. So, of course, you can appeal because he would have standing. It's adverse to him. He didn't even try. Lol. Pursuant to the rules, he qualified as a non-party who could have appealed. Instead, he waited at least 6 months after he was re-indicted to contest it. For those reasons, we have no jurisdiction. And if we did, we wouldn't do it anyway because of law of the case. So, yeah. So we're not going to decide it because we literally don't have jurisdiction because you waived it. But even if we could review it, we still deny it because of law of the case. So take your pick. This is not old. This was released today. This is brand new. On October the 14th of 2021, Smollett filed another motion to dismiss the indictment, alleging the state breached its immunity type non-prosecution. Yeah, it's an immunity agreement, except for, not. In violation of his right not to be hauled in court on the same charges. Generally, we review a court's ruling on a motion to discharge judgments under abuse of discretion. However, when the issues are purely legal, our standard review is de novo, which makes sense. Double jeopardy is, in the end, a legal question. Did it attach or not, right? So we're not reviewing the facts, we're reviewing the law. In this case, he's alleging denial of due process and claims denial was sufficiently prejudicial to require dismissal of the charges against him. These are questions of the law. Sounds like it to me. Smollett alleges that he performed his part of the alleged non-prosecution agreement with the prosecutor's office by performing his community service and forfeiting $10,000 of bond. He asserts the record is clear that Cook County prosecutors had the intention and indeed an agreement to bargain away the state's ability to re-prosecute him in exchange for the money. We disagree. Hype. The record does not establish that Smollett entered into a non-prosecution agreement, which you probably want to get that in writing, by the way, with the prosecutors, in which the prosecutor agreed to forego further prosecution in exchange for his performance of whatever. On the contrary, the record clearly shows that in March of 2019, the prosecutor stated in court that they'd reviewed Smollett's volunteer service in the community, volunteer service in the community, an agreement to forfeit his bond in making the state's motion to null pros. At the end of the argument, Smollett agreed that the only indication of the record of an agreement is the transcript of the proceeding. No other documents, no other writings, no emails. If there was an agreement not to prosecute, sounds like the kind of thing you might want to get in writing. A reasonably competent attorney seems like we do that. We don't have any evidence the null pros was a immunity grant. So yeah. Under well-established law, the null pros is not a final deposition of the case and will not bar another prosecution. Yeah, so exactly. A null pros is not a final disposition. Incidentally, by way of comparison, Alec Baldwin, as I'm sure you will recall, was null prost for his the original criminal complaint, and recently has been re-indicted for the same incident, the Rust shooting. A null pros is not a dismissal with prejudice. It's a we don't want to go for it at this time. The decision to null pros a charge lies within the discretion of the prosecutor, and the trial court may not deny the motion under normal circumstances. Facts. A null pros is not an acquittal, but it's like a non-suit or discontinuation of a civil suit. Exactly. It's the person voluntarily dropping their lawsuit. Yeah. And leaves the matter in the same condition as it were before it commenced. If the null process entered before jeopardy attaches, which again is when the jury is sworn in, the state may re-prosecute the defendant subject to other statutory or constitutional defenses, absent fundamental fairness, bad faith, or harassment. So, if the prosecutor is just, dismissing, re-bringing it, dismissing, re-bringing it, just to harass you, at some point, the court will be like, you're just being a jerk, so you can't bring this anymore. Or if the prosecutor is doing it for bad faith reasons, which, would be manifest on the record, the courts will step in then because of your due process rights. But this ain't it. Those things are not present. Once he charges null pros, the proceedings are terminated with respect to the particular charge, and the defendant is free to go without entering into any recognizance to appear at any other time, because there is at that moment no charges pending. Here, the state's null pros of the indictment was not the final disposition of the case, and as we considered below, jeopardy didn't attach. Therefore, the state was not barred from re-prosecution. After the null pros was entered, Smollett was free to go without entering into any sort of agreement to appear another time, which is the bargain he made. There is no ambiguity as to what occurred between them, and the contrary dissent's position, further proceedings are not necessary to add clarity. As thoroughly explained by the Office of the Special Prosecutor, throughout this action, Smollett has offered numerous, different, and oftentimes conflicting framings of the purported agreement that was struck between them. He can't even agree as to what it is amongst himself. For example, the trial court called the disposition reached an informal agreement, analogous to a negotiated plea agreement, a negotiated agreement, effectively pre-trial diversion, a contractual immunity agreement, and an immunity type agreement. In his appeal, he's tossed aside these previous descriptions and landed on a non-prosecution agreement. but the record only supports one conclusion. He bargained for and received the null pros, which is not a legal bar. Sounds right to me. Sounds right to me. Presumptively relying on the principles of contract law, which incidentally is a perfectly valid way to do this, by the way. That's typically how we review plea agreements, non-prosecution agreements. We look at them in contract law. So when you enter a plea, when you enter a bargain, we look to the letter of the agreement. And sometimes that has been known to hoist the prosecutor on their own petard at a later time. Seen a couple cases like that, which is always hilarious. But yeah, it's typically what we look to. We look at contract language, so that's fine. The rights of the state in a unilateral null pros can be bargained away when making a bilateral agreement. That is, an agreement where both people agree and presumably exchange something between them. However, no court has ever applied principles of contract law in interpreting the scope of the no process. Okay, fair. Unlike the instant case, in People v. Smith, the prosecutor advised the trial court that there'd be an outright dismissal if defendant met her expectations of the cooperation and immunity agreement. Sounds a lot more specific. Defendant fulfilled her obligations and the state voluntarily dismissed based on cooperation. When the state reindicted the defendant more than a year later, the trial court dismissed the indictment, finding that by moving to dismiss the charge, the prosecutor acknowledged the receipt of the benefit from the defendant's performance. The court expressly held the prosecutor's use of the phrase outright dismissal indicated the prosecutor intended the dismissal to be an acquittal, not a null pros. Given that language and also language of cooperation immunity agreement, those sound more specific to me. Under those circumstances, the trial court found that reindicting the defendant violated due process. On appeal, the reviewing court agreed, noting that once the state has elected to dismiss, the dismissal is absolute. And if null pros had been intended, it's likely the charges would have been null pros. So there's a legal difference between the two things. There's a legal difference between a dismissal, especially given this kind of language, and a null pros. In Stepansky, the defendant entered in cooperation agreement with a police officer, which he agreed to cooperate in the arrest of two individuals in exchange for not being charged with possession of a controlled substance. When the defendant was later indicted, the trial court found his due process rights had been violated because he'd fulfilled his part of the bargain and incriminated himself based on promises made to him. Facts. This incidentally is, by the way, why police won't promise you anything. They'll speak in very vague terms, right? Because they won't say anything definitive. Like the police will say something like, if you confess, it will help your case. It will help you out. What does that mean? What does that mean? It'll help your case. It'll help you out. What does that mean? All right. If you cooperate with us, the judge will look upon you with more favor. What does that mean? What does that mean? Right? So it's too vague to be enforced. But when the police say, hey, if you cooperate with us by doing so and so, you're all good to go and we won't prosecute you. Yeah, that's a bargain. Also, just don't talk to the police in general, but yeah. Our Supreme Court finding the defendant's substantive due process rights were violated when the state breached his agreement with a police officer. Yeah, this is why police tend not to say definitive things. Unlike in Stepansky, Smollett did not enter into a cooperation agreement with the prosecutor's office. Cooperation agreements are neither plea agreements nor a grant of immunity. They arise when the state agrees to limit prosecution in some manner in consideration for cooperation. In addition, the terms of Stepansky, cooperation agreement provide that if defendant cooperated in the arrest of two individuals, he would not be charged, which sounds a lot more specific. If you cooperate with us in helping get these two people arrested, you will not be charged. That sounds like something more definitive. What does that mean? Sounds like something definitive to me. In contrast, he's already been indicted prior to the motion on null pros charges, and the record doesn't contain any evidence the prosecutor's office agreed Smollett would be further prosecuted in exchange for forfeiting his bond. In People v. Starks, after being found guilty of armed robbery, the defendant alleged the state's attorney's office had agreed before trial to dismiss the charge if he had passed a polygraph. Defendant alleged he submitted to and passed the test on basis of the representation. Our Supreme Court found that if there was an agreement as alleged, and if they fulfilled their part of it, the state must fulfill its part. And therefore, assuming the agreement existed, by submitting himself to the polygraph, the defendant surrendered his Fifth Amendment privilege. So if the agreement existed, then they have to fulfill the agreement, because it's like, give us polygraph and you pass, we're done. That's a specific agreement. It sounds like consideration, sounds like a verbal agreement. You are 100% correct to me. Like, I do polygraph, you dismiss that. And that sounds pretty definitive to me. I don't have to really resolve what they were talking about. Unlike in Starks, where defendant testified at the post-trial hearing that the prosecution told him if he passed the polygraph, the charge would be dismissed, the record in this case is silent regarding any non-prosecution agreement. Nothing like that. No questions are left by the state's actions on that date. As previously discussed, the only disposition requested was to be null prost. Similarly, in People v. Merriam, a police officer offered not to arrest the defendant for narcotics possession in exchange for his cooperation in helping to find and produce handguns, which the defendant accepted and then fulfilled as part of the bargain. We found where the defendant proved there was an enforceable agreement and the police had authority to promise not to arrest, and the police had the authority to promise that. To allow the government to receive the benefits of its bargain without providing reciprocal benefit for a defendant would do more than violate private contractual rights. It would offend all notions of fairness in criminal proceedings, which of course are protected by due process. This isn't just your ordinary contract, of course, because, Constitution. So, there's that. So while contract rights are typically how we evaluate them, there are some other considerations beyond that, because Constitution. In contrast, the record in the instant case establishes in March the prosecution's office only agreed to null pros. Accordingly, it's failed to establish due process. Fair. Let's give double jeopardy a shot. I think this is his best odds. So let's see if he can make this work. I mean, we already know they're going to say no, but why did they say no? I think it's probably because the jury wasn't sworn or anything close to that, would be my bet. But let's see what they say. Smollett also contends the trial court erred in denying his motion to dismiss the second indictment based on the violation of his rights against double jeopardy. Generally, review the trial court's ruling on a motion to dismiss based on double jeopardy grounds for abuse of discretion. However, whereas here there's no disputed facts, then just pure law. There are no disputed facts that are relevant to this. We all know exactly what happened in exactly what sequence. So it's a pure issue of law. So let's de novo from ground zero. Let's just consider it. The double jeopardy clause of the Fifth Amendment provides no person shall be subject to the same offense to be twice put in jeopardy of life or limb. The Illinois Constitution, of course, also prohibits double jeopardy. Illinois courts have interpreted our double jeopardy clause identically to the federal counterpart, which incidentally, by the way, isn't a given, just, for the record. So some states, in fact, let me just state it this way. Some states have adopted language that is similar to the language contained, for example, in the Bill of Rights. Sometimes it's word for word identical. Sometimes it's not. However, even where it is word for word identical, sometimes the state Supreme Court has said, as a matter of our state and constitution, we interpret it differently, which, by the way, isn't like a wholly unusual concept in law. For example, in the UCC, the Uniform Commercial Code, most states have adopted most parts of it, and the language is almost identical every single time. But the decisions from the respective states about exactly what the exact same language means differs a little bit. So even given the exact same language between states, different states interpret it differently. So And of course, a state is always free to grant more rights than the federal constitution requires. So as long as they're interpreting even the same language in a way that grants more rights, no problem. So they can have different language, they can have the same language, they can interpret differently. As long as they're giving more, that's fine. And if they give the exact same, that's also fine. The only thing they can't do is just give less. So that's perfectly fine. The threshold is whether jeopardy has attached. Observing the starting point for any double jeopardy analysis, of course, is determining whether jeopardy attached. Protections against double jeopardy are triggered only after an individual has been subject to the hazards of trial and possible conviction. In a jury trial, jeopardy attaches when the jury is impaneled and sworn. What did I tell you? In a bench trial, jeopardy attaches when the first witness is sworn and the case be giving heavy evidence. What did I tell you? In the context of guilty plea, jeopardy attaches when the court accepts the plea. In the instance case, 12 days after arraignment, the state null prost. No jury had been impaneled, no witness had been sworn in, no evidence had been introduced, and Smollett had not pled guilty or not guilty at this point. Because none of the actions occurred, jeopardy didn't attach. Da-da-da-cha. So yeah, I mean, that was what I thought the answer was. So yeah, that doesn't surprise me. That's just what I thought. Smollett erroneously argues jeopardy attached when the judge accepted a negotiated disposition between him and the prosecutor's office, involving his performance of community service and forfeiture of bond. Smollett relies on several decisions from other states to support his argument that negotiated disposition is tantamount to alternative or deferred prosecution or pretrial diversion program. In addition to the fact that decisions from the foreign jurisdictions are not binding on us, and they actually cite authority for that, which why would they have to, but whatever. The record doesn't show that Smollett ever enrolled in or completed an alternative or diffused prosecution or pretrial program. Such programs require formalities, none of which are present here. So even where other states have these processes that, are alternatives to, criminal prosecutions, there are still rules for that are formal, and you have to go through that process. So yeah, when you have certain things that can be jeopardy attaches because the states have specific procedures for that, and that wasn't what happened here. So even if we were inclined to apply the law, which we're not, because we don't have to, you didn't do any of the things, so it's not on point. I appreciate you, Diz Poodle, for trying to help the numbers on Twitch. I appreciate it. We appreciate everyone who watches on Twitch to help the channel grow. You all kick ass. We have emojis now on Twitch. I added those. And hypothetically, I fixed the issue with clips. So you should be able to make clips of the channel and post them into the Twitch chat. Hopefully. Yeah. Jeopardy protects the integrity and finality of judgment. The prosecutor's null pros of the first case didn't represent final judgment because, as previously discussed, a null pros is not final disposition of the case and will not bar prosecution in the same offense. It is not an acquittal. Also, as previously discussed, if a null pros is entered before jeopardy attaches, the state may re-prosecute the defendant subject to other constraints and absent any sort of fundamental unfairness, bad faith, or harassment. Given the absence of the non-prosecution agreement with the prosecutor's office, re-prosecuting Smollett was not fundamentally unfair. Because that isn't that kind of situation, Because the charges against Smollett were null prost before the jeopardy had attached, the subsequent prosecution did not violate his right against double jeopardy. Smollett's reliance on the United States versus Chartreux in the Supreme Court of the United States, in which the from the 1880s, in which the defendant's penalty was in full satisfaction, compromise, and settlement of the indictment, is misplaced. In the instant case, the forfeiture of Smollett's $10,000 bond to the city of Chicago was not in full satisfaction of the costs of the city incurred in investigating his crimes. Nice touch. Smollett also argues his conviction violates the spirit of double jeopardy and should be reversed on public policy grounds. Smollett repeatedly cites Illinois versus Somerville from the U.S. Supreme Court for the proposition the application of double jeopardy principles should not be done in a rigid, mechanical manner. Okay. In Somerville, after the defendant was indicted by a jury and was impaneled, the state realized the indictment was fatally deficient, and under the law at the time, that could not be cured. So they indicted him. They went to trial. They swore in the jury, and only apparently after that fact realized the indictment was broken. Oops. And the law in the jurisdiction didn't allow the indictment to be fixed at this point. Oops. After the state informed the trial court of the flaw, the court granted the state's motion for a mistrial. Thereafter, the defendant was indicted for a second time. Tisk, tisk, tisk. Thank you, Chris A., for 10 gift memberships. We appreciate it. As the second indictment corrected the flaw of the first indictment, a jury found the defendant guilty, and ultimately the issue of double jeopardy reached the U.S. Supreme Court. In analyzing whether the trial court's declaration of a mistrial barred the state from retrying the defendant with a valid indictment, the court made multiple references to eschewing rigid mechanisms. And also, jeopardy had attached because the jury was sworn in. So even if you want to apply rigid mechanisms, you're there. Again, we said this in the earlier stream. The law kind of disfavors what the label you put on it is, right? We don't like the label because people might change the label and then say, oh, it's this because they changed the label, right? So we were discussing that in the earlier stream. So the court said, okay, this is a mistrial. Is it though? Is it a mistrial? No, it's not. No, it's not. There's no manifest necessity. The jury hasn't hung, so forth and so on. So it's just a dismiss. And therefore double jeopardy attached, and therefore you can't re-prosecute. Works for me. More recently, in Martinez versus Illinois, U.S. Supreme Court, the court reiterated there are clear bright line rules as to when jeopardy attaches. In fact, the court rejected any argument that Somerville stood for the proposition that whether jeopardy had attached was subject to flexibility. That wasn't the things we're talking about. The court observed in Somerville the decline to apply a rigid mechanical reasoning in answering a very different question, not whether jeopardy had attached, but whether the manner in it terminated barred retrial, which it does. Martinez demonstrated that Smollett's use of public policy arguments cannot change the bright line rule that jeopardy never attached in his first case. Well, I mean, strictly speaking, Illinois could, of course, disagree with the Supreme Court here because it would be affording more than the Supreme Court required. So Illinois could ignore it, but are they going to? I highly doubt it. I'm not seeing the Illinois Supreme Court take this case, unless it's to further smack them around. Consequently, the trial court denied motion for dismiss based on double jeopardy. The Osserando brothers filed a motion to disqualify the attorney from representing Smollett in the case based on asserted conflict of interest. They asserted in February 2019, and February, this next day, the attorney held 2 distinct consultations with him. They also alleged the attorney discussed facts of the case with their mother. The attorney advised the trial court that the affidavits attached to the motion to disqualify were not accurate, and he didn't talk to the brothers on the phone, and never met with the brothers in their life, and didn't know what they sound like. Seems like a disputed fact. At the attorney's request, the court held an ex parte meeting with the other attorney, which was an attorney for the Osserando brothers, regarding information they allegedly disclosed. So, let's have a hearing on it. Whoa, there's an idea. How about that? There was a motion to disqualify. For which the attorney had notice, and then they gave him a hearing in accordance with due process. That sounds nice. The special prosecutor's office filed a bill of particulars, which is just an indictment with extra steps, give you more detail, in which it asserted that the attorney had at least 4 distinct conversations with them about the case over the phone, with the attorney or with Bola being present for at least 2. The court held an in-camera evidentiary hearing. Perfectly fine to do it in camera. Again, because we don't want to unduly embarrass the attorneys if we don't have to. Fair enough. They had a motion to disqualify. The Ola Bolsa and Miss Osterenda were the only witnesses who testified at the hearing. The trial court, having conducted a hearing and considering the facts and reliability of the witnesses as the finder of fact as to this issue, found the totality of evidence clearly and convincingly shows that at different points the attorneys talked to the brothers and their mother. Okay? And the topics discussed included immunity, the $3,500 check that paid for the assault because he paid by check because he's an idiot, the search warrant, items seized during the execution of the search warrant, laws about hate crimes, and handling of intense media. The court said it firmly believed that the interest of Mr. Smollett to have the lawyer of his choice when his liberty at stakes outweighed any other valid and good faith concerns of the office's prosecutor and the witness. So he's like, okay, yeah, the attorney did these things, but, I'm not overly concerned about it here. Okay, it seems like a plausible decision a judge could theoretically make. Although the courts did not disqualify him from representing Smollett, the court held the attorney wouldn't be allowed to cross-examine the family members at trial. The court explained that the attorney may appear as counsel for Smollett with the following limitations. Some other member of the highly qualified defense team shall cross-examine the family witnesses should the matter be adjudicated. Fair enough, so we'll let someone else do it. So that solves that problem. Everyone's happy. We move on with our lives. There is a presumption in favor of defense counsel of his choice. There sure is. As you guys have noted in the Delphi murders, I'm fully prepared to be proven wrong by the Supreme Court, by the way, if it comes to that. It's just a prediction. It's just a guess. I don't know. It's not clear. The Supreme Court argument we decided today was clear. It's like, if this is 9-0, I'm going to lose my mind. So I don't know. We'll see. The court must determine if there's a conflict or potential for conflict. If the court finds a conflict, it must consider the interests threatened by the conflict or potential conflict. Determine whether the interests threatened by the conflict are weighty enough to overcome the presumption of the person being able to choose their own attorney. The court may consider and weigh 4 factors, including, but presumably not limited to, defendant's interest in having undivided loyalty of counsel. Does he have divided loyalties? The state's right to a fair trial in which defense counsel acts ethically and does use confidential information to attack the state's witness. Fair enough. You have to use it based on information you acquired properly. The appearance of impropriety should a jury learn of the conflict, and the possibility of continued representation will provide grounds for returning. This is not an exhaustive list, as the court should seek to fairly consider all the interests that are affected by the conflict. Further, where appropriate, the court should consider whether there are alternatives to disqualification that remove the conflict while still protecting the right of counsel. So, is there another way to go about this that would solve the problem? We review the trial court's decision to disqualify for abuse of discretion. That's typically the correct standard. An abuse of discretion only occurs where the trial court's decision is arbitrary, fanciful, or unreasonable degree. No reasonable person would agree with it. It's the reasonable man test. It's always the reasonable man test. It's always the reasonable man test when it boils down. Would the reasonably prudent judge do this? Would the reasonable ordinary judge do this? Is it within the bounds of reason? It's always the reasonable man test at the end of the day. Based on evidence introduced at hearing, the court reasonably conclude that in the interest of light of topics discussed and circumstances in which they are discussed, the threshold criteria for an attorney-client relationship has been met. A person who consults with a lawyer about the possibility of forming an attorney-client relationship with respect to a matter is a prospective client, which typically would form a conflict of interest to the extent there's adversity. Because the court reasonably concluded the threshold had been met, there could be a potential for conflict. An attorney-client relationship can be created at the initial interview between the client and the interview. It's possible this confidential information passed during the interview is sufficient to disqualify the attorney from representing the opposed party in a related litigation. Yep. Even where no attorney-client relationship exists, a lawyer who has learned of information for a prospective client shall not use or reveal that information except as other rules might permit. So yeah, upon your very first meeting with your attorney, that is enough to, the initial meeting is enough to have, we call it a prospective client, but fundamentally there's really no difference, really, when it boils it down. The court, I mean, the distinctions are so minor as to be ignored for the most part. The court ultimately concluded that the remedy of disqualification was available, but decided to consider other approaches to best achieve the interests of justice. The court decided the attorney could continue to represent Smollett, but other members of the defense team would be required to cross-examine the members. Although the attorney was not allowed to cross-examine the family members, he was not prevented from being present during the cross-examination, preparing questions for the cross-examination, or from discussing their testimony or attacking their credibility during opening and closing arguments. The trial court resolution fairly balanced the interests of the state to a right of a fair trial and Smollett's right to counsel the choice. The court's ruling on the motion to disqualify was not fanciful, arbitrary, or unreasonable, such that no reasonable judge would do it. The man on the bus appears once again. Thank you for the 736 of you who are here. By the way, I appreciate every one of you who are here and spending some time with me, and I hope that you're learning some things today about due process and issues relating to conflicts and double jeopardy and so forth and so on. So this is a good case. It's a good vehicle for us to discuss many legal issues. So I hope you're enjoying it. Thank you for being here. Before trial, Smollett filed a motion for discovery under Illinois Supreme Court rules. After the hearing on the motion, Smollett requested that the special prosecutor disclose notes made during the meeting with the brothers. He argued the brothers had met with hours of representatives of the special prosecutor, and defense did not have notes as to what's discussed in their statements at the time. In response, the special prosecutor argued it didn't generate any reports from the meeting and had only attorney notes consisting of internal opinions, theories, conclusions, which is pure work product as opposed to memorandum. So yeah, the court denied the motion to compel, finding that they are work product. Fair. Under the rules, upon motion of the defense, the state must disclose defense counsel following material and information within its possession. Thank you, Ann Rasmussen, for gifting 20 gift memberships. We really appreciate it. We appreciate everyone who follows and donates, and we appreciate everyone who uses their Amazon Prime to subscribe over on Twitch. All of it makes a difference. Defense requested the court to conduct an in-camera inspection of the notes, which was denied. Under the rules, upon written motion of defense, the state must disclose defense counsel the following material: the names and last known addresses of persons with whom the state intends to call as witnesses, together with relevant written or recorded statements, memoranda containing substantially verbatim reports of their oral statements, and lists of memorandum reporting or summarizing oral statements. Upon written motion of defense, reports or summarizing oral statements shall be examined by the court in camera and found to be substantially verbatim shall be disclosed, but just that. The purpose of the discovery rules is to protect against surprise, unfairness, and inadequate preparation. Although compliance with the discovery rules is mandatory, the failure to comply with the rules does not require reversal absent a showing of prejudice. It's defendant's burden to show prejudice, because again, the trial court gets a fair amount of discretion. So we, tend to view this in a way that will, that will validate the trial court's decision, because that's how we roll. At the hearing upon the first motion to compel discovery, the special prosecutor informed the court that the notes from the meeting were attorney notes and work product, noting their internal opinions, theories, and conclusions. The court, without examining them, denied the motion based on notes being protected work product. Although the state is not required to disclose its privileged work product, in the ears of the defense for that matter, The court, not the prosecutor, must make the determination regarding whether the memorandum summarizing a written statement contains privileged material. And we cite a decision that concludes the trial court erred when it relied on the assistant state's attorney's representation. The notes did not contain verbatim statements. Knowing the determination whether memorandum contains verbatim or substantially verbatim reports is to be made by the court, not the prosecutor. When the states resist disclosure, asserting the statement or portion thereof is irrelevant or contains privilege or is not substantially verbatim, the court must make the statement in camera and decide whether or not it's properly reproducible. So apparently the court erred by not reviewing them in camera because that's the relevant law in this jurisdiction. So fair enough. In Young, the Supreme Court found trial court erred when it did not conduct the in-camera review of the assistant state's attorney's notes from a review with the state's witness, but found the defendant was not prejudiced by the non-disclosure and the error was harmless beyond reasonable doubt. The court concluded the denial of in-camera inspection did not deprive the defendant of an opportunity to effectively cross-examine the witness, thereby denying him the right of confrontation. The court noted the witness testimony was not the only evidence tending to establish defendant's guilt, and denial of the opportunity to use notes in cross-examining did not reliably affect the fair process. So a judge who could do the in-camera proceedings and decide no after privately reviewing them and making the decision, that's fine. That's what you'd expect. In the immediate case, although the trial court erred in denying the motion to compel discovery of the notes from the meeting without conducting an in-camera review of the notes, the error was harmless beyond doubt. In addition to testimony and police reports, there's substantial evidence that corroborates the brothers' testimony and tend to establish guilt, including video evidence, cell phone data, and text messages. Therefore, we cannot say there's a reasonable doubt the defendant would not have been convicted if the trial court had conducted the meeting. So yeah, we note, okay, was it an error not to do the in-camera? Yeah, but does that error matter? Which is typically the standard on appeal, right? Unless it's structural error, in which case we don't care about harmless. But this isn't structural error, right? It's just a bad call by the judge, not them fucking up the process in the structure of the thing. So here, in this case, they say, okay, the trial court erred by not reviewing the notes in camera to decide for themselves whether or not what the prosecutor was saying was true. They were supposed to do that. So the trial court made a mistake. Okay, does it matter? No, because, so much stuff is corroborating their testimony that, the testimony is reliable. Those notes don't contain anything that would have helped you anyway. That sounds about right for the appellate court to me. In Sasbo, upon which Smollett relies, the testimony issue was the only evidence tending to establish the guilt. See, that's a much bigger problem, right? So in that case, the testimony was the only evidence showing guilt. It's a one witness case, which is always super. So, so that's a problem because we can't attack the witness. That's a problem. So in the present case, as discussed, the brother's testimony was corroborated by substantial evidence that established the guilt of disorderly conduct, that he was the victim of attack. Yeah, so not that situation here. We find that Smollett has failed to establish he was prejudiced by the special prosecutor's non-disclosure of the notes. Facts. This analysis sounds right to me. Not having any problem with it sounds good to me. Defendant next contends the trial court violated his constitutional right to a public trial by the imposition of COVID restrictions during jury selection. All right. Do I really need to read this to tell you this argument's not going to work? On October 2020, a month before Smollett's scheduled trial date, the trial court emailed the parties informing them that while the criminal courts were operating, they were operating with 50% capacity limits. This meant only 57 people would be allowed in the courtroom during the trial. The court informed the media that all the seats in the courtroom were being reserved for prospective jurors. However, the court agreed to keep the doors open on both sides for the media to listen. So, unfortunately, we don't have space for the media in the courtroom right now. But, you can sit outside the door and listen. That's about as best we can do. Yep. Under the Sixth Amendment, a criminal defendant is guaranteed the right to a public trial. The Illinois Constitution guarantees the same. This protection requires the trial court to take all reasonable measures to ensure public attendance at a trial. The right of a public trial protects both the defendant and the public. For the defendant, the public trials allows the public to observe that he's fairly adjudicated, ensures the trier of fact recognizes the importance of the matter, ensures trial judges and prosecutors carry out their duties responsibly, encourages witness to testify, and discourages witness from lying because the community can see it. For the community at large, a public trial enhances both basic fairness and appearance of fairness. We initially note that Smollett failed to contemporaneously object. We can kind of stop writing at that point, to be honest. We can kind of stop writing because he didn't object. So you use it or you lose it, my friends. You use it or you lose it. Based on Smollett's failure to object, he has failed to preserve the claim. When defendant forfeits a claim, we only consider if the error was plain error. The plain error doctrine bypasses normal forfeiture proceedings and allows the reviewing court to consider unpreserved claims of error in specific circumstances. The doctrine applies where a clear or obvious error has occurred, and either the evidence was so closely balanced that error alone threatened to tip the scales of justice, regardless of the seriousness of the error, or the error was so serious it affected the fairness of the defendant. The first step in the plain error analysis is to determine if it's obvious or clear. So, yeah. Courtroom closure is to be avoided, but there are some circumstances in which it's justified, says the U.S. Supreme Court. When Smollett trial began, the COVID restrictions in effect resulted in allowing only 57 people being allowed in the courtroom. Allowing 50 prospective jurors, court staff, and parties' attorneys strained this capacity limit and raised obvious health concerns. Under the backdrop, the court properly determined allowing members of the media and implicitly other members of the public to be present would be problematic. The court's decision to keep the doors open during the jury selection allowed people in the hallway, including members of the public, to observe the proceedings inside the courtroom. This accommodation reasonably balanced the public's right to observe the jury and small rights to a public trial with logistical concerns relating to the pandemic. Consequently, Smollett cannot demonstrate that clearly or obviously erred, and he's not established plain, obvious, manifest, ridiculous error. Accordingly, their rights to a public trial was not violated. Facts. Smollett also points to the trial court improperly excluding a civilian referred to as Bella Baz from the courtroom during the trial. Even assuming arguendo that one individual was excluded, his constitutional right to a public trial was not violated, as it proceeded in front of his family and friends, as well as members of the public. So, excluding random person, the public was still allowed to watch. So, yeah. Noting from the precedent that where the trial court removed several spectators who were not members of the immediate family and thus didn't have direct interest from the courtroom while the 14-year-old sexual assault victim testified, none of the evils of closed trials were impacted, but it's because the trial court didn't impose restrictions on the media, which were still allowed access to the proceedings. Seems reasonable to me. Let's talk about voir dire. Smollett next contends the trial court violated the rules by not allowing defense counsel to directly question prospective jurors during the voir dire. Prior to trial, counsel stated he had a normal way of picking jurors and would do all of it from talking during the voir dire. However, the court also stated he would invite input from the lawyers on specific questions asked, emphasizing the degree of pretrial publicity warranted such consideration. In response, Smollett submitted more than 50 questions on topics such as potential jurors' consumption of media, awareness of Smollett, and questions about race, sexual orientation, hate crimes, false crimes, and COVID. The record rejects the majority of the proposed questions were incorporated into the proceedings. So, for whatever reason, the publicity, whatever, the judge said, okay, I'll be asking all the questions during voir dire. I'll be asking the questions, but obviously you can submit your questions to me. And if I think they're okay, then I'll ask the questions. And apparently he asked most of the questions that were presented. So, okay. It seems probably all right, you know? The defendant has a constitutional right. Hey, a new subscriber on Twitch. Awesome. I always love seeing that purple icon for Twitch. Kick ass. Go kick ass on Twitch. Hopefully you can post clips now. The defendant has a constitutional right to an impartial jury, and voir dire is a procedure that helps protect the right. The primary purpose of voir dire is to ensure selection of a fair jury. Questioning potential jurors is designed to identify whether any jurors have basis or harbor an opinion that would affect the determination of the proceedings. The trial court is primarily responsible for initiating and conducting voir dire. To this end, the court controls the manner, extent, and scope of voir dire. Immediately, the trial court must permit the parties to supplement its examination by such direct inquiry as the court deems proper. Although the Illinois Supreme Court said the word shall, the court is not required to permit the parties to supplement an examination by their own direct inquiry. And apparently there's a case that says exactly that. So again, we've interpreted the law and we say, okay, although it says shall allow direct inquiry, we say, okay, that's not actually what it means. Hey, another subscriber on Twitch. Hey, we're getting somewhere. Thank you for subscribing on Twitch. This is kick-ass. All right. Rather, the court must consider the factors listed in a rule, the length of the court's examination, complexity of the case, and type of charges, and then determine, based on those factors, whether direct questioning by the attorneys would be appropriate. While the court maintains discretion in examining whether to allow parties to supplement an examination by direct inquiry, the discretion is guided by a preference for permitting inquiry by the attorneys if it's sought. Trial courts may not simply dispense with attorney questioning whenever they want, although rare, there are circumstances in which it's appropriate for the court to reject the parties to have the attorney directly question jurors. In balancing the right to supplement the examination with direct inquiry, the court must also ensure that voir dire does not act as a means of indoctrinating the jury or impaling a jury with particular predisposition. To this end, specific questions tailored to the facts of the case and intended to serve as a preliminary final argument are usually not allowed. Yeah, we're not trying to try the case before we try the case. We review the court's conduct during voir dire for abuse of discretion, which is again typically the standard, and we look for a lot. This only occurs where the conduct of the trial court thwarts the purpose of the voir dire examination, namely selection of a jury free from bias or prejudice. The trial court does not abuse its discretion using voir dire if the process or procedure employed create a reasonable assurance that prejudice would be discovered. In People v. Gonzalez, the trial court did not allow any of the parties to question potential jurors and prevented the attorneys from asking any follow-up questions. On appeal, this court observed that nothing in the record indicates the court considered factors in the rule before denying attorneys to the ability to question. We note that before even voir dire began, the court determined it would not allow any direct questioning, and later simply stated there'd be no direct supplemental questioning because it was a new regime. Because the court decided it would dispense with all direct attorney questioning without consideration of the rule, the court failed to comply with the rule. In the instant case, unlike Gonzalez, the trial court openly invited input from the parties throughout voir dire. The court recognized that while the case generated significant pretrial publicity, disorderly conduct charges were not particularly complex. They're not particularly complex. This is relatively easy. Did he lie to the police? You're there, right? It doesn't require a lot. And while the court never expressly discussed the length of examination by the court, such consideration was implicit based on the court's invitation to the parties to submit questions they wanted to the court to ask the prospective jurors, and its understanding that Smollett wanted several of his own questions asked. Yeah, Jussie was let out of jail. He served something like 6 days previously. Moreover, the court acknowledged the significant pretrial publicity in the case, implied that its examination of potential jurors would be more extensive than normal. In addition, while the record conducts, the trial court conducted a lengthy and comprehensive voir dire, which incorporated many of Jussie's questions. Jussie Smollett, the famous French lawyer. I hope your dad will be well, Darth Mac. We wish him a lot of health. Still, Smollett argues that the factors not listed in the rules, defense counsel might attempt to interfere with the jurors with the question. While the rule lists only 3 factors the court must consider, the court contemplation of the effect of defense counsel questioning on jurors was not unreasonable, because the court had a responsible to act that voir dire does not act as a means of indoctrinating the jury. Trial court's voir dire demonstrated steadfast effort to ferret out any potential jurors who harbored bias or prejudice against Smollett. The court questions the jurors about their media consumption and their membership in clubs or organizations involving police issues, civil rights, LGBTQ rights, and asked whether it had watched the show Empire or the television show Smollett was on, or that was the television show. Additionally, the court asked prospective jurors if they performed any research about the case and asked follow-up questions where necessary to ensure impartiality. For example, when one juror said she'd researched the case, the court asked about the nature of the research. The juror responded her daughter worked near the location of the crime, causing the juror to perform research because she was concerned. When pressed regarding whether she could put aside feelings she had towards the parties, she wavered and ultimately said she was unsure. In a later discussion with the parties, the court sua sponte suggested striking the juror for cause, and by agreement of the parties was discharged. So it sounds like the court is certainly trying to, provide good process. And they cite a case in which an aggravated criminal sexual assault case where during voir dire, the trial court barred defense counsel from individually questioning potential jurors about their own personal abuse issues, and instead determined it would be the sole inquirer, which, their own experiences with abuse might be a relevant consideration as to whether or not the juror could be fair in an abuse case. I mean, it doesn't mean they can't be fair, but, it's something to take note of as you're kind of considering the issue. Was conducted with the primary purpose to exclude jurors who are unwilling and unable to be arbitrators and therefore implement in accordance with the rule. Although the court did not ask every single voir dire question proposed by Jussie, this court is not required to do so. View the record in the entirety, the trial court complied with the rules. Sounds fine to me. Thank you again for Troy R. for subscribing over on Twitch. We love all of our Twitch subscribers. We appreciate everyone who helps watch on Twitch. What is a hype train? It is the hype train is a Twitch thing, and basically, as you give subscriptions or bits or other things to the channel at a fast enough rate, it triggers the hype train. Says, hey, you guys are contributing at a rate. Let's keep it going. Choo choo. Let's get that hype train going. Choo choo. Okay, Batson motions. Oh, this should be good. Smollett next contends the trial court in denying his motions, alleging the special prosecutor used his preemptory challenge in a discriminatory manner. Discrimination on the basis of race, discrimination on the basis of sex. We exclude them because they're black, because they're women. That's Batson. Specifically, Smollett challenges the exclusion of 4 African-American jurors and 1 prospective juror who the defense believed identified as gay. Yeah. The Equal Protection Clause of the Constitution prohibits the state from using its preemptory challenges during jury selection. As explained in Batson, there's a 3-step process for determining whether it's improper. First, the defendant must establish the prima facie case, showing the state exercised its preemptory challenge, which is just throw them off the jury because I want to. No particular reason, just because I want to. Which the defendant can rebut as pretextual. And then the trial court is required to determine whether the defendant has demonstrated intentional discrimination. In the instant case, although the trial court invited the prosecutors to proffer race-neutral reasons for exercising its challenges, the court never made a finding that Smollett had made the prima facie showing the exercise of challenge because of race. At the first stage, the defense burden is not great, and it can make the prima facie showing merely by presenting evidence sufficient to permit the trial judge to observe the inference. There are several relevant factors the court can decide in whether showing it's made the prima facie showing. The racial identity between the party exercising the challenge and the excluded person, patterns of strikes against people of race on the veneer, which is all the jurors we start with at the beginning, the massive panel, the massive group of jurors we start with is the veneer, And then when we get to the sworn jurors, that's the jury panel. Fancy terms. The prosecution's questions and statements of the challenged party during voir dire and while exercising their preemptory challenges, whether the excluded persons, veneer persons. I've never seen that term before. Okay, I've never quite seen it phrased that way, but okay, they're veneer persons. We're a heterogeneous group sharing race as the only common characteristic, and the race of defendant, victims, and witnesses. In determining whether the defense made the prima facie showing, the trial court must consider the totality of facts and all relevant circumstances surrounding preemptory strikes to see if it gives rise to the purpose. At the first stage of Batson will not overturn the court's conclusion unless it's against manifest weight of the evidence. Once again, because in this instance, the trial court is the finder of fact. And once again, we're talking about anything the reasonable juror, which in this case, the judge, anything the reasonable judge could do. Right? So, yeah, manifest weight. Yeah, that's kind of what we're looking for. Which occurs when the opposite conclusion is plainly evident, or the finding is arbitrary, unreasonable, or not based on the evidence. Ordinarily, the person asserting Batson has the burden of proving the prima facie case and preserving the record, and any ambiguities in the record will be construed against the party. The exception to the rule occurs when the trial court sua sponte raises the claim, which is not the case here. At the onset, as discussed, when the trial court entertained the Batson motion, it directed the prosecutor's office to proffer race-neutral reasons for excluding the challenges on the prospective jurors, even though it never made the prima facie showing. Although in the court's own words, was being cautious and apparently attempting to present a more comprehensive record by allowing the prosecutor's office to proffer race-neutral reasons, the procedure had the effect of collapsing the first and second stages, which our Supreme Court has warned against. Despite this, the court's ultimate conclusion that Smollett failed to establish the prima facie showing are not against the manifest weight of the evidence, so get wrecked. Smollett's Batson motions failed to establish the prima facie showing discrimination occurred because of race, because he provided no argument other than notifying they're all African American. When the race of the excluded people, as compared to the defendant, is a relevant factor in determining whether they made the prima facie cases, but one of several factors. In order to make the prima facie showing, it was incumbent on Smollett to present evidence sufficient to permit the judge to draw the inference discrimination occurred. Although the burden is not great, it is a burden. Merely raising the motion based on the exercise of the challenge to the prospective juror, who is African American, without any additional argument, is insufficient to carry the burden. As a general rule, the more members of the group that are challenged without more will not establish the prima facie case. So the mere number itself is not enough. At least as far as Illinois is concerned, your mileage may vary in other states. For instance, in Heard, a defendant contended the state violated Batson when it exercised 5 challenges on African Americans. Defendant's argument in favor of Batson violation rested solely on the basis the prosecution used its challenge to exclude 5 African Americans. After observing the well-established principle, defendant cannot make the prima facie showing by simply pointing to the number of the challenges. Our own Supreme Court asserted because the defendant has not provided any other information to support his claim of discrimination, he has failed to establish the prima facie case. Smollett's arguments to the trial court are the same and therefore insufficient for the same reason. Sounds about right to me. Nevertheless, Smollett posits the trial court erred in analyzing its Batson motions by failing to consider the relevant factors listed in the case called Davis, which he argues that are in favor, to determine whether the prima facie case was met. It was his burden to present evidence and argument based on the factors when bringing the motions before the court, and he can't make that argument now for the first time on appeal. Yeah, so you got to be, your attorneys have got to be sharp. You use it or you lose it. You use it or you lose it, right? If you don't object, you lose it. And so the Court of Appeals analysis is correct, right? Look, here are multiple factors. Your argument is the court failed to consider the factors. Did you tell the trial court that? Did you say, hey, Your Honor, your analysis seems to potentially be missing some steps. I'd like to respectfully remind Your Honor multiple factors and request that you make findings relevant to each of the factors. Did you say that? You say anything like that? No? Okay, then you waive the issue. You got to preserve your issues. You can't make the argument for the first time on appeal. You got to preserve your issues, man. Yeah. At no point did the trial court deny him an opportunity to expand on the motions and make the argument on the record. Smollett simply raised his Mattson motion and never attempted to develop the comprehensive argument. He cannot claim the court failed to consider the factors he didn't ask the court to consider. Yeah. By not buttressing his motion with supporting arguments, he failed to establish the prima facie case, and he can't bitch about it now. Smollett further highlights the impaneled jury contained only one African American, a contention he also raised in post-trial motions. However, during actual jury selection, in particular making his Batson motion concerning the jurors, after the jury had been selected, Smollett never stated for the record the composition of the jury. So we don't know who's on the jury because you didn't bother to mention it. It is clear the accused has the burden of properly preserving the record, and neither statements made in the brief nor assertions in the motion can substitute for the record. So there's no evidence on the record as to the racial composition of the jury because you failed to bring it up. So we have no idea how many African Americans sat on the jury because you forgot to mention it. That's a pretty big fail. There's only one. How do you know that? How do we know that? We can only go on the record, man. You're trying to bring new facts to the appellate court. That doesn't go well. The appellate court doesn't do facts. They do law. So, yeah. Good times. Equally as important, Smollett never made the argument to the trial court about the composition of the jury and the lack of African. So you never mentioned it. Hey, judge, can't help noticing that of the 12 jurors, only one is black. You know, that seems like maybe that's a problem. Do you want to maybe give this another go? Kelda asked in chat, shouldn't the names of the jury be released? It depends on your state. It totally depends on your state. Some states release it immediately. Some states never release it. Totally depends. And it's not on it's not preserved because they didn't say that. So yeah. Consequently, the court's conclusion Smollett failed to make the prima facie showing is not against the weight of the evidence. Lastly, Smollett argues that the state police the special prosecutor acted unlawfully when exercising his preemptory challenge because the prospective juror, whom Smollett identified as gay. It sounds to me suspiciously like Mr. Smollett, you were engaging in a little stereotyping. Did you ask if he was gay? So you assumed he was gay based on his conduct? Sounds kind of bigoted to me. I thought we weren't allowed to do that. I thought you weren't allowed to assume someone's gay by the way they act. But you assume it. Fun. The Jury Act provides except as otherwise provided, no person is qualified may be excluded in the court of the states on the basis of sexual orientation. Our legislature added sexual orientation as a prospective class under the law they passed, effective 2020, and intended the amendment to codify Batson to protect sexual orientation. However, similar to Batson's concerning race, he failed to make the prima facie case based on orientation. Well, all he did was highlight that he identified as gay, so apparently he mentioned it at some point, we think, yet failed to present any evidence to permit the court to draw the inference discrimination occurred. Liam007 gives $4.99. Thank you for the super chat. Smollett probably deserves jail, but the state negotiated a plea and he accepted. How is jeopardy not attached? They didn't negotiate a plea. They didn't negotiate a plea. They negotiated a null pros. You know, they negotiated dismissal of the well, dismissal isn't even the right word technically. They negotiated the prosecutor dropping the charges. They didn't negotiate a plea. So yeah, the law is a precise thing. Thank you for the super chat. Consequently, the court's conclusion Smollett failed to make the prima facie showing that the orientation was not against the manifest way of the evidence, and the court didn't consider that, and that's all fine. Yeah, a plea actually requires pleading guilty. Yeah, that's how you know there wasn't a plea agreement, because there was no plea. Yeah, Tony, A. Henninger notes that correctly. Yeah, that's how you know it wasn't a plea agreement. There was no plea. He never said, yeah, I'm guilty in court. That didn't happen. Smollett next contends that during the cross-examination of one of the detectives, the police lead investigator of the case, and the Osserando brother, the trial court made improper comments in the presence of the jury that violates due process. At trial, the detective detailed the Chicago Police Department's investigation of Smollett. Although originally considered to be a crime victim, the subsequent investigation indicated not so much. Smollett's theory of the defense was the police never took his allegations seriously and prematurely concluded he had falsely reported a crime. Due to cross-examination, Detective Thesis testified he could not recall whether he or his partner had ever asked Bola whether the perpetrator beat up on Smollett's face. While defense counsel played a video from the interrogation for the purpose of impeachment, they objected based on relevance. In response, the trial court instructed defense counsel to go ahead. They then proceeded to ask the detective if the questions were appropriate. The court sua sponte sustained the prior objection and instructed defense counsel to ask another question. So after looking at the evidence, he's like, yeah, no, can't do that. Defense counsel again asked the detective about referring to Smollett's pretty face. The state prosecutor or special prosecutor objected based on relevance. In denying the relevance objective, the court stated he can't answer that he can answer that he did say that. So what? Did detectives say it? Defense counsel said, I'm sorry, that's offensive. I'm sorry, I need a break. That's too much. Wow, you're kind of a little weak there, man. Okay. Is this too much for you? Wow, okay. After a short recess, the jury was admonished the trials are contested, and occasionally professionals can get testy. The jury is instructed not to consider that one way or other, not the comments by the lawyers and not the comments by the court. The court added, the rulings are rulings, the evidence is evidence. I don't want to concern yourself with the fact that some voices were raised, and there's a little bit of consternation. According to Smollett, the court's remark of so what improperly dismissed his attempt to establish homophobia as a central theory. That's reading a lot into a lot. Dude, no. The defense counsel asked the detective a series of questions based on discovery of suspected narcotics during the execution of a search warrant on the brother's home. In sustaining the objection, the trial court asserted every situation is different for a variety of reasons. When defense counsel responded, even for cocaine and heroin, the court responded, you can try different questions. Don't assume every case and every police officer. That's not fair. Ask a different question. According to Smollett, the court's response to the objection had the effect of condoning the investigative decisions. The judge is actually judging. Wow. The judge is actually judging and saying, you know, that question is improper. Try another way. Try a different question. The judge is actually judging and saying, hey, that question isn't a proper question. Wow. Who would have thought? During another exchange with defense counsel, trial court instructed counsel to continue the cross-examination without editorializing and trying to add, and defense counsel objected, excuse me? The court continued to trial defense counsel just trying to be a good lawyer, but the question is wrong, and he will answer the question why he had the gun fingerprinted. You asked him before, and he can answer, but don't add any other information. Seems fair, right? So, like, we don't want to editorialize. Just ask the question. Just ask the question, man. Don't add your opinion to it. Just ask the question. After a further back and forth, defense counsel said he's just trying to make a record. The court asked counsel not to argue, saying, just ask the question, please. I want to finish the witness. Fair. Please don't editorialize. Please don't, you know, just ask the question. Just ask the question. Yeah. Ann Ramusin in chat says, thanks for takedown. I don't understand much legal talk, but you made gut feelings understandable. Well, that is my objective on this channel. I try to demystify the law and it helped to explain it. That is my goal. I want you to understand what's happening and why. And so thank you, because I try very hard to make it understandable. And we can simplify this without losing much. And so I appreciate the compliment. That's very nice. I try hard. During defense counsel's cross-examination, the trial court interjected the defense counsel was getting a little left of field and instructed her to focus on the cross-examination. The trial court is allowed to manage the court. The trial court is allowed to, you know, keep the the judge is allowed to force counsel to keep their eye on the ball. Ball's over here, guys. Please direct your attention to the ball. The ball is shiny. Please look at the ball. You must look at the ball. Defense counsel asked for a sidebar, which during the court denied. Directing her continue. Lol. Love it. Can we have a sidebar? No. This judge is making rulings. This judge has decided he's not up for this. Move on. Feel it. Feel it. Different judges have different personalities when it comes to such things. The reasonably prudent judge could have more sidebars or not sidebars. You know, you get a fair opportunity to be heard once. Right? You get a fair opportunity to be heard once. And then the court's like, well, I've decided that issue. Moving right along. You're like, I want more. No. But you're... No. Ultimately, a sidebar was... Ultimately, a sidebar was convened because apparently they bitched some more. And Smollett moved for a mistrial, which was denied. No shit. Before cross-examination renewed, the court again admonished the jury that words come out like focus or collateral during the conversations with the attorneys and instructed the jury not to consider the comments. So the judge seems to be trying to keep the jury also looking at the nice shiny ball. Hey guys, I just want to let you know there were some elevated words a moment ago. You know, that can happen sometimes. Please don't hold it against them. You know, decide this on, you know, the facts. It's okay. Let's not hold it against them. Hey, you might have overheard some words, but you know, please don't consider that. That's not facts. So that sounds like the judge is trying to help the jury along and keeping them focused on the nice shiny ball. Liam 007 says, hope you're for some young thug trial. The lines are super blurry, and this type of constitutional shit show is where you do your best work. Thank you. Additionally, the court reminded the jury its decision on Smollett's guilt must be based solely on the evidence and law. This sounds like the judge is doing what he should do to me. According to Smollett, they were particularly prejudicial because the court used the word collateral and informed counsel she was not focused. No. The judge is actually, you know, there in the room. The Court of Appeals is not. So they're going to defer to the trial court pretty hard. The trial court does in fact get the ability to, you know, manage their courtroom. And Rasmussen gives 5 gift memberships. Thank you very much. We're upset with the judge because he didn't do exactly what we wanted to all the time. Yeah. Finally, Smollett challenges the court's efforts to expedite cross-examination. For example, in sustaining the objection, the court said, you got to rephrase that, please. That's hearsay. The jury will disregard, find another question, and move on. Another counsel the court told let's go and come on during various parts of the cross-examination. Yeah, I don't have a problem with that. I don't have a problem with, like, we're stalled out here. Let's move. Let's go. Check, let's go. You're wasting time. Let's move it. Anything approaching anything in the order of reasonable. Trial courts get a lot of discretion. Who your judge matters a lot. Don't piss off the judge. Every defendant, regardless of the nature of the proof against him, is entitled to a trial that's free from improper and prejudicial comments. While the court has broad discretion in presiding over a trial, it must refrain from comments that are insinuating its opinion of the case. A hostile attitude towards defense, an inference defense counsel presentation is unimportant, or suggest the defense counsel is attempting to present a case in an improper manner may be prejudicial and erroneous. This is of critical importance during a jury trial because court's influence over the jury is great. However, such comments are not reversible unless they constitute a material factor in the conviction or such an effect the verdict was tainted. So, no. Even assuming arguendo the trial court's remarks were improper, which I don't find, but, let's assume it anyway, the extensive curative instructions obviates any potential prejudice. Facts. Because, again, we presume as a matter of law, the jury won't follow the instructions. So the judge saying ignore all that, we assume the jury does that because that's what we assume. The jury follows instructions, don't you know? Liam 007 says, I listened to your McLaren versus Georgia Scottish breakdown twice today. I feel obliged to give something for getting me through the last 4 hours of my shit job. Thank you. I appreciate it. I hope you had a good time and you learned a lot about the law and how Georgia apparently doesn't understand the law. Somehow, unanimously, they don't understand the law. They're going to get whacked by the Supreme Court unanimously and hopefully get beaten to death a little bit on the page if I had my druthers about it. Where was I? Again, I apologize. Additionally, a trial judge retains wide latitude to impose reasonable limits on cross-examination based on concerns about harassment, prejudice, confusion of the issues, witness savees, or interrogation that's repetitive or of little relevance. Facts. Let's go. Chop, chop, chop. We've got 30 more pages. It's lengthy. I hope you're here for it. Telling defense counsel to focus and move away from collateral issues during cross-examination of Ola served to inform defense counsel they are awaiting areas of the minimum relevance for issues at trial and to continue their cross-examination of more relevant issues. Although the record suggests the court may have become impatient with defense counsel at various points, the showing of impatience does not evidence bias because the judge is a little frustrated because you're wasting their time. As Smollett's argument that the trial court improperly defended detective investigation decision and basically accused the defense counsel of editorializing, the record shows the isolated comments made in the course of a nearly 2-week trial, which are allowed to extensively examine the witnesses, and thus not material. So, yeah, not a problem. All right, as to a criminal issue. The next contention on appeal is the trial court abused its discretion when it failed to give an Illinois pattern jury instruction. Every state has just pattern instructions. They are well tested. They've been vetted through multiple appeals. In multiple cases, they represent the best combined knowledge about what the jury instructions should be. So as a typical rule, you use them. Sometimes they can be modified a little, but they're a good thing to use. Okay, the rule states when a witness says he was involved in the commission of a crime with the defendant, the testimony of the witness is subject to suspicion and should be considered by you by caution. The test in determining whether a witness is an accomplice for the purpose of accomplice witness instruction is whether the witness could have been indicted for the offense in question either as principal under the theory of accountability. Generally, the trial court has discretion to determine jury instructions. Here, Smollett was charged with knowingly reporting to a police officer he had been the victim of a hate crime battery, aggravated battery, and he knew at the time of the reporting there were no reasonable grounds for believing the offense had been committed. Accordingly, the test for whether to give accomplished jury instructions in this case was whether the brothers could have been indicted for knowingly transmitting to the police that a hate crime had committed without their knowledge. There is no reasonable ground for believing the offenses have been committed. While the brothers readily admitted to planning and carrying out the attack, there was no evidence introduced that they were involved in making the report. So they can't be charged as accomplices with respect to that crime, because that was Smollett on himself. So there's no need to give the instruction about accomplices, because with respect to this crime, there are no accomplices. Specifically, one is not an accomplice merely because he has guilty knowledge. Facts, just because I know you're going to commit a crime doesn't mean I'm guilty of shit. Right? It requires actions on my part. Or even where he is admitted participant in a related but distinct offense. You know, if it's distinct, then it doesn't read on to the other one. Both the brothers testified at trial they would not have gone along with the hoax if they knew Smollett was going to file the false police report. Based on the record, it cannot be said the trial court's failure to give the instruction was arbitrary, fanciful, or unreasonable to agree no reasonable judge would do it. Yeah, that's about right. Smollett's next contention on appeal is his rights to a fair trial and due process were violated when the special prosecutor committed several acts of misconduct. Defense witness testified he saw a white male leaving the scene on the night of the crime. The witness also testified on January 9th he told the special prosecutor he saw a white male on the night of the question. The prosecutor typed up the statement for him to sign, which he read and initialed. Defense counsel then elicited that the witness felt pressure and threatened to say something he didn't see. When defense counsel asked whether he saw the person in court who pressured and threatened him and asked him to point him out, he pointed to the special prosecutor. At this point, the court called for a sidebar. Defendant argues the fair trial implications are obvious and states that Moore's credibility was negatively impacted in front of the jury due to having inconsistent statements. Yeah, that's kind of a problem. Since defense called him to the stand for presumably knowing he was going to testify inconsistently with the sworn statement because of pressure exerted on him by the special prosecutor, it's disingenuous to say he was prejudiced by that situation. So yeah, if you kind of induce it, you can't complain about it. Hey, they're going to testify inconsistently. I'm putting them on the stand. Now I want to complain that they're testifying inconsistently, and that's bad. Yeah, that's not how that works at all. Defense counsel made a motion to disqualify the special prosecutor based on the testimony, which the court denied. Smollett contends, citing People versus Rivera, trial court should have granted the motion to disqualify since the prosecutor has essentially turned in a witness. Only if he's an essential witness. Smollett did not explain how the prosecutor turned into a witness or which portions of Rivera were relevant. We reinstate a reviewing court is entitled, we restate, a reviewing court is entitled to have the issues defined with authority and not simply a depository in which the appellate party may dump its argument. Breach. You got to tell the trial court what the issue is, right? Maybe the trial court is making a mistake of law. You know, it's possible. Did you give them a fair opportunity? Did you tell them? Did you let them know? Did you object? No? Oh. In Rivera, the defendant filed a written pretrial motion to suppress made to a police officer and the assistant state's attorney after he was in custody, but before charges had been filed. Prior to suppression, the state moved to disqualify defense counsel, who was listed as a witness in defense's motion to suppress. Arguing defense counsel was prohibited from representing the defendant and acting as a witness in the same proceeding. The court granted the motion, finding the written motion to suppress rendered the counsel a material witness. On appeal, defendant argued the trial court's decision to disqualify violated his right to counsel. Our Supreme Court found where counsel acts as both an advocate and witness, defense is required to withdraw. That's pretty much the rule everywhere that I know of. You can't be both at the same time. Here, unlike Rivera, defense counsel moved to disqualify the special prosecutor after the witness he called accused the prosecutor of pressuring the witness prior to trial. Special prosecutor was not called to testify and was not listed as a witness at trial. This qualification is dramatic, and the court must be vigilant in ensuring motions disqualified are not misused as a tactical weapon for the purpose of harassment and delay. We find the trial court did not abuse its discretion. Sounds about right to me. You didn't, make this an issue until the middle of trial when you had notice of the issue. You could have brought this up, in a pre-trial stage. You can't sit on it and just use it whenever you want. Like we talked about this with John Hopkins, remember? Yeah, are you just learning just now all these wonderful things about Juror 1 and his wife? I don't think so, right? So you can't sit on it and hold it in reserve in your pocket and then spring it, at a time when it's convenient for you. That is not how that works. You have to make objections contemporaneously. So, presumably, you knew about this conflict long ago because, you're good attorneys, and you could have made a motion to disqualify the prosecutor, which we don't know how that motion would have gone, but, either way, the fact that you're making it now is bad pool, man. That's bad pool. You can't do that, man. Smollett also contends that the special prosecutor improperly shifted the burden of proof from the prosecutor to Smollett during rebuttal. The special prosecutor maintains the comment was made in response to defense counsel. Prosecutors generally have wide latitude in closing argument and may comment on the evidence and any reasonable inference, even if inferences reflect negatively on the defendant. No shit. We consider statements in the context of closing arguments as a whole, and instead of examining the phrases in a vacuum. Fair, right? You need to look at the whole thing to properly understand the context. Wow. Defense counsel stated during argument there's a lot of missing data. You don't have the whole video. You don't know who he's talking to, and I'm going to get into that. In rebuttal, the special prosecutor said next, they told you there was missing video. They gave you no evidence that any of the video was missing. Sounds like a pretty decent rebuttal to me. It's well established the state always has the burden of proving beyond a reasonable doubt the elements of the crime. However, if defense counsel provokes a response, the defendant cannot complain about it. Yeah, that sounds pretty right to me. Hey, you're missing the video. Hey, they never showed you there was any missing video. Sounds like a perfectly appropriate response to me. Chaucerian Fraud says, hey, Kurt, is accusing the judge of impropriety just because you need to appeal a normal way of representing your client? No. No, it's really not. It tends to happen more in high-profile cases, but it's not normal. And not for nothing, by the way, because you as an attorney don't really want to do that unless you have to. Because, the legal community is kind of small at the end of the day, particularly as it relates to a particular kind of practice. The number of attorneys who are doing a particular kind of practice in a particular location tends to be a relatively small club. And the number of judges is a relatively small club. So you really, as an attorney, really don't want to lambaste the judge in appeal if you don't have to, because one, you'll piss that judge off, who you'll see again, and two, you'll probably piss all the judges off because they don't really like it doing either. So as a general proposition, it's rare because you don't really want to pull that trigger unless you have to. So, yeah. Your reputation somewhat matters. Deep thoughts. Here, defense counsel argues in closing that the phrase "a lot of missing data" from the videos of the brother that are played for the jury. Accordingly, disputed comment in the rebuttal to that no evidence was presented to support the allegation of missing data is properly viewed as a response to defense. Moreover, conviction will only be reversed where the prosecution's comments are so inflammatory or so flagrant they deny due process. Here, the remark about missing video was an isolated statement, did not create reversible error. Yeah, it sounds about right to me. Post-arrest silence. Smollett's final prosecutorial misconduct argument, as we're on 45 of 69, is that the special prosecutor impermissibly impeached Smollett with post-arrest silence in 2 instances, which you can't do, obviously. First, during direct examination of the witness, Detective Thesis, the police ever asked Smollett if he ever made statements saying the brothers did nothing wrong. Defense counsel didn't object. The second instance was where the special prosecutor asked Bola if Smollett ever made a statement to the public where he admitted the crime was a hoax. Smollett argues the question implies post-arrest silence by hiding failure to tell police officers the same story during his investigation. In Doyle, the Supreme Court held it was a violation of due process of the 14th Amendment for the state to use a post-arrest silence for impeachment. Illinois has expanded on the rule by including pre-Miranda silence, finding that under Illinois law, it's permissible to impeach a defendant with either post-arrest silence or pre-arrest silence, regardless of whether the silence occurred before or after Miranda warnings. At trial, a screenshot of text messages was sent by Smollett to Bola on February the 14th before the arrest was entered into evidence, which, text messages are where you weren't silent, so there's that. It stated in part, 1,000% you and your brother did nothing wrong and never would. I'm making a statement so everyone knows. So the next question is, did you? Yeah. Because you said you would, did you? When the special prosecutor ever asked Smollett if he ever made a statement to the public where he admitted the hate crime was a hoax, trial court sustained the objection and instructed the jury to disregard. So the question was stricken. The judge agreed with you. No harm. A trial judge's prompt answer in sustaining an objection will be sufficient to cure any error in a question. That's what judges are for. Here, the trial court cured any prejudicial impact the comment might have had by sustaining the objection and ordering the comment to be stricken. That does the trick. That does the trick. Good Morning America interview. Smollett's next contention is the trial court abused its discretion in allowing the entirety of an interview he gave on the television show Good Morning America to go back to the jury when the jury only saw a portion of the interview at the trial for impeachment. Really? Really? Well, it's a party admission to point out the obvious. It's a party admission adverse to interest. So, there's that. And they want the whole tape to go back to the jury so the jury can look at the whole thing if they want to. Wow. The special prosecutor responds that the interview had been admitted into evidence and published to the jury. So it had been published during the case in chief, and therefore they allowed the interview because it had been admitted and published. That does it. And then in trial, they actually showed only portions of it, but what they admitted was the whole thing. It's evidence. It's also the rule of completeness. You're supposed to admit the whole thing because the jury needs to be able to consider the thing in its context. So, yeah. As an initial matter, we noticed that Jussie Smollett, famous French actor, who's both French and black and gay, did not cite pages in the record where the GMA interview was allegedly used for impeachment purposes, so it wasn't even used for that purpose. Failure to indicate record citations where the argument requires examination of the record results in forfeiture. You didn't tell the appellate court where it was on the record. Great. That's just great. So you appeal saying, hey, it's impeachment, and then you don't cite the record. Good work. That's just genius work. That's just genius work. Further, for forfeiture aside, we find the court properly allowed the video of the interview to be taken in the jury room. It's well established that whether evidentiary items should be taken in the jury rooms rests within the discretion of the judge, whose decisions will not be disturbed unless there's abuse of discretion. Yeah, and good luck with that. In People versus Montez, the defendant argued the trial court should not have allowed an audio recording, which had been admitted as substantive evidence, to go back to the jury. So they objected. Whoa. The jury only heard portions of the recording during trial. The appellate court acknowledged a recording may, in discretion, be employed in the jury room. It found that where the court properly admitted the recording as substantive evidence and the jury heard portions of it at trial, there was no abuse of discretion in permitting the entire recording to go back to the jury room. Wow, what an amazing idea. Like in Montez, the trial court did not abuse its discretion in allowing the interview, which had been properly admitted as substantive evidence, to be taken to the jury room. Smollett has not shown the ruling was arbitrary, fanciful, or unreasonable. Accordingly, not so much. We're going to object to the sentence next. This should be good. This should be good. We're going to object to the sentence for the 6 felonies at 150 days. That sentence was unreasonable. 150 days for the 6 felonies. That's cruel and unusual, man. Okie dokie. Okie dokie. 5 felonies. I stand corrected. You're correct. The jury only convicted him of 5. I stand corrected. Smollett then next contends the trial court abuses discretion in imposing extensive sentencing terms given the nature of the offense charge and the overwhelming mitigation. One was dismissed along the way? Okay, whatever. Fair enough. They only convicted of 5. The grand jury charged 6. I forgot what happened with the other one. Yeah. Can an appeal result in a longer sentence? It's possible. Although, strictly speaking, they'd order resentencing. They wouldn't determine what the sentence is, but it's possible. If it's wildly insufficient, it's happened. So it's possible. So he's convicted of disorderly conduct, which is a felony. For a class 4 felony, the trial court consents the defendant to a term of imprisonment that shall be a determined sentence of not less than 1 year and not more than 3 years. The court can also sentence the defendants to paroled imprisonment, which shall be for a definite term of up to 18 months. If the court sends the defendant to probation, the period of probation shall not exceed 30 months, and the court shall specify the conditions of probation as one does. The law requires that the court shall not require as condition of sentence of probation or conditional discharge the offender be committed to a period of imprisonment of less than in excess of 6 months. Here, the trial court imposed a sentence of 30 months probation, with the first 150 days to be served in jail. The sentence was within the statutory range and thus presumed proper. Nevertheless, Smollett argues the conditions of probation require him to spend the first 150 days in jail was excessive, but because he was convicted of a non-violent felony, he received a pre-sentence report from adult probation department that ranked him as low risk. He was not a recidivist. There was a health risk due to COVID, lol. And custody setting posed a threat to Smollett due to his unpopularity. He also posits the 150J was unnecessary since the trial judge had imposed the maximum fine. Yeah. Initially, we note the fine does not render jail time unnecessary, since the statute allows for both. Additionally, we presume the trial court considered all mitigation evidence that was presented. To rebut the presumption, defendant must make the affirmative showing the court did not consider relevant factors. Aside from naming mitigating factors he presumably thinks should have negated prohibition conditions, Smollett fails to make any affirmative showing the court failed to give weight to mitigating evidence. As noted above, a class 4 felony is punishable by a term of imprisonment of 1 to 3 years, or a periodic imprisonment of up to 18 months, which is not what happened here. Although the court had the authority to impose up to 6 months in jail, he was ordered to serve 150 days in jail. We find nothing in the record that trial court abused its discretion. Preach. Restitution. Smollett argues the trial court erred in ordering restitution be paid to the city because the conviction of disorderly conduct does not allow municipalities or public agencies to be viewed as victims under the restitution statute. That's nice. The city of Chicago filed an amicus curiae. The special prosecutor and the city both responded Illinois law allows for the police department to be a victim, and we agree. The restitution statute, which is contained in the Code of Corrections, authorizes the court to order restitution when a party has received any injury to his or her person or damage or his or her real property as a result of criminal act. The statute provides the court shall assess the actual out-of-pocket expenses, loss, damage, and injury proximately caused by the conduct. The victim of a restitution statute is someone who suffered harm. Whereas here the issue is where the restitution order is authorized, it's a question of law. While several cases in Illinois have held police departments or governing agencies is not considered a victim within the meaning of the restitution statute, there is no per se rule prohibiting law enforcement from receiving restitution. They cite authority. We do not hold that law enforcement can never be entitled. So some courts say no as it relates to certain cases, but it isn't an absolute rule. In Dernberger, the court vacated an order of restitution to the police department for investigation of a crime of disorderly conduct because defendant's offense did not proximately cause the expense. Yeah, there you go. So it didn't cause the expense. That works. Because the police department only sought restitution for hours that officers and other employees spent on the job investigating non-existent crimes, the losses were not compensatable. The court said the money that officers were paid for hours they spent claim was money they would have been paid anyway. So the officers are getting a salary. So there's that. There's no evidence that anyone who investigated was paid anything beyond normal compensation. That makes sense. Here, however, the testimony at trial revealed that 24 to 26 detectives worked on the investigation, totaling more than 3,000 hours of work, reviewing 1,500 hours of video footage. At the time, as I'm sure you'll remember, this was a huge national scandal. Kamala Harris was saying it's modern-day lynching and so forth and so on. It was a huge deal. It was a very big deal. The man was 1 inch from causing a massive race riot. The police had some strong incentives to dump quite a lot of manpower into this investigation. So they went a little above and beyond what they would typically do. At sentencing, the victim impact statement from Chicago attested the police department spent 1,837 overtime hours investigating the report, costing the city $130,000 in overtime. So it isn't money we would have spent otherwise. It's extra money because he was 1 inch from causing a race riot, and we need to figure out what the hell's going on. So that doesn't make sense. You know? Unlike in Dernberger, the resolution of this case did not reimburse the city for normal costs of investigating, but rather the overtime. Because they did in fact suffer an out-of-pocket expense they wouldn't normally do, therefore, restitution. That makes logical sense. I'm on board for that. Having found the city was entitled to restitution, we now turn the argument the trial court abused discretion by ordering them to pay $120,000 to the city because the receipts justifying the restitution were fraught with issues, which sounds suspiciously like a determination of fact, right? The receipts were fraught with issues? Boy, oh boy, it sounds like the fact finder's got to figure out what the truth is. The trial court's determination on restitution will not be reversed absent abuse of discretion. No shit. When setting the restitution amount, a trial court shall assess actual out-of-pocket expenses and other damages. The court must determine actual costs incurred by the victim. A guess is not sufficient. Alleged losses which are unsupported may not be used as a basis. Here the record shows the trial court properly assessed the out-of-pocket expenses incurred by Chicago. Trial court heard the city's victim impact statement, which attests to Chicago Police Department had spent the 1,800 overtime hours. This is not wholly unsupported. To the contrary, the special prosecutor submitted accounting of expenses the city incurred as a result. So, there may be some problems, there may be some ambiguity, but, there may be some contrary facts, but nothing that this court can't deal with. To the extent Smollett argues that the descriptions were lacking on some of the time cards, officer names on the time cards were not introduced at all. Some overtime reports were undated and other discrepancies. We note he never objected to this. And therefore he's forfeited the argument. While Smollett challenged restitution order in his motion to reconsider, it was based on the argument Chicago Police Department could not be considered a victim of the statute, not on the amount or the accounting. Thus depriving the trial court of an ability to review this. We find People versus Hansen to be illustrative. There, the defendant failed to object to the amount of restitution at trial. The appellate court found that given the specificity of the amount, we doubt the state just made up the amount within any basis. The court found that where the only error complained of is the absence of some time receipt or testimony, the record proving the victim incurred the amount offered by a state, it's forfeited on appeal. Likewise, with the case at bar where Smollett did not object to trial or in his motion to reconsider to the amount incurred, he forfeits the issue. And then there's a dissenting judge, which we will not read, but that is pretty decent stuff. So, yeah. So that sounds like reasoned analysis to my ear. So, yeah. So I somewhat do not think the Supreme Court is likely to take this case. Don't think they're going to go out of their way to hear this, given the whole saga. So I think his odds of getting the Supreme Court to reverse this are pretty low. So he still has to do something like 144 days. Something like that. And so he can appeal to the Supreme Court and then cert denied. So we can look forward to him going back to prison probably sometime in the spring. Yeah. That's where we're sitting. So he's getting exactly what he deserves, okay? He the man. I'm sure many of you remember that period of time. It was really uncomfortable there on race relations for a moment. Jussie Smollett caused a massive issue. It was somewhat palpable. Got the vice president and all the other people commenting about modern day lynching and stuff like that, right? So, like, yeah, do you think the Supreme Court of Illinois is likely to review this and be like, okay, you think the U.S. Supreme Court is going to take cert on this? So yeah, I don't really think that's going to happen. JTF gives 5 gift memberships. So if justice is kind to us, then hopefully he'll be spending time back in jail sometime in the spring. We'll see. So I appreciate everyone who has joined me today. The harmless error analysis was suspect. Even if it is suspect, I mean, once again, like I don't necessarily mind you disagreeing with the court in parts, but it is, of course, their judgment. And do you really think the Supreme Court is going to go out of their way to hear this? I don't. So yeah, I mean, two judges say harmless error. I, at least reading it, didn't think it was ridiculous to think it was harmless because there's so much other evidence, right? There's so much other evidence. It's not a one witness case with, no external evidence. The witness is the thing, and which the notes about what the prosecutor saw would go directly to the witness and what he did or did not see or what he did not say and potentially impeach him because it's a one witness case, right? In this case, it's not a one witness case. We've got tapes and videos and the brothers and everything else. So I tend to agree harmless error analysis. So I'll disagree with you on that one, but that's one man's opinion. Yeah, it was very problematic at the time for sure. My bot says that they've received 1,000 messages today with Restream chat. Cool. We've had 1,000 chats today. That's nice. Where's a trial whose verdict you think should be overturned on appeal? I would have said Murdaugh. I would have at least given the Court of Appeals. I thought that Murdaugh had very good arguments on appeal on 403 because the amount of financial testimony that was offered at trial seemed to be so excessive as to be a violation of Rule 403, right? Some of it might have been relevant, but the total amount of it became it basically became the financial fraud trial. There was so much evidence offered. And so there was a very good argument, I thought, on appeal that the trial judge erred by allowing so much evidence in that it became substantially more prejudicial than probative. So there's an example where I would have said I would entertain that on appeal. Of course, that became a little moot when we got the whole issue of the jury misconduct, which is now the issue. But what's Rule 403? Rule 403 is a rule. It's a safety rule in the rules of evidence. It's a rule that says even if evidence is otherwise admissible, it can be excluded. For example, among other things, if it would mislead the jury, if it's substantially more prejudicial than probative, if it's not, the core of the case and a bunch of other stuff, right? So it's a safety rule. It's a safety rule. It says, okay, even if evidence can otherwise be offered, you can exclude it if it would be really, really bad. Inflame the passions of the jury, that kind of thing. So I thought there was so much brought in, a little bit of it would have been relevant. But I think so much, it was so excessive that I thought substantially more prejudicial and probative. So there's an example where I think the appellate court would be well within their rights to entertain the appeal. Yeah. So that's an example. Yeah, it taints the jury. Because the problem is, did they really convict him because of the murder? You might say to yourself, well, it's obvious they did. But there was so much financial stuff brought in. So what does their guilty verdict represent? What does their guilty verdict represent? What was it based on? The murder? Well, you have so much financial crimes testimony to such a large degree that, at least to my mind, there is reason to question what the jury was convicting him of. So that's sort of what we're talking about. Yeah. We want the jury to convict him because he committed murder, not because he did the financial crimes. That's a different trial. In fact, that trial just recently wrapped. But, you know, that's a trial for itself. They went like through 10 years of financial records or something. They went through 10 years of financial crimes that he did. I'm like, dude, you know. Queen Olive says it was based on being at the kennels after lying about it. You don't know that. No one knows that. But even if the jury said that, what was going through their mind is a whole nother problem. It unduly taints them. So that was the problem. Wasn't the door originally kicked open by the defense? Even assuming it was kicked open by the defense, you still have the same considerations, right? That's the safety rule. So assuming the financial stuff wasn't relevant and the defense made it relevant, it becomes relevant. But you still have the same problem. Just because the defense kicks open the door doesn't mean that you can, you know, do whatever the hell you want. There are limits, man. The fundamental fairness to the defense is still a thing. So you can't inflame the jury. You can't go off issue. You can't, you know, yeah. So did the defense open the door? But it doesn't matter. That would just allow them to offer some of it, not necessarily all of it. I thought it was too much. Word I was off topic? Not really. We're just at the end of the stream. We're just talking right now. We're already into the stream. We already got past the issue. We're just having law discussion now. We're talking about other issues. That's fine. I like talking to you guys. What else? Yeah. It's still a home door, not a garage door. There you go. That's a good way of putting it. It's a home door, not a garage door. There you go. That's a reasonable way of analogizing the issue. Good. That's good. I like that. How long before the Supreme Court starts issuing decisions? It's possible to start issuing them fairly soon. Sometimes they issue some in early December. So it's possible. They're going to start issuing some pretty soon. We'll see. What's my opinion about the Supreme Court declining the Chauvin case? U.S. Supreme Court, I have no problem with that. The state Supreme Court, yeah, I don't. I think that the appeal court somewhat deliberately and purposefully avoided the issue dealing with Chauvin's issues with all the publicity and media, right? So the defense appealed on a whole bunch of grounds, as one would expect, but the best issue for them was the media publicity was so intense that the case should have been potentially sent somewhere else, or other measures should have been taken, like sequestering the jury or something. And at oral arguments, like the defense lawyer, the person on appeal arguing for Chauvin, tried to start right away with the media and the hoopla about it. And the appeal court, like immediately, like right away, started asking questions about other things. I think he only had 15 minutes of oral argument too, and he never got back to it, right? So the appeal court had no interest in discussing that. And then in their decision, I think they somewhat hand waved away the problem. They didn't really confront it. They were a little bit unduly dismissive to the issue. And so I think the Supreme Court of the state denying review was perhaps improper, because it required a little bit more consideration, I thought, than what we saw. Didn't Chauvin plead guilty in federal court? Yeah. I think he tried to appeal his state conviction to the U.S. Supreme Court. So, but yeah. The U.S. Supreme Court of the grounds to decline. The Supreme Court doesn't need grounds to decline. The Supreme Court doesn't need grounds to decline. The Supreme Court only takes something like 0.7% of all the cases that are presented to them. Supreme Court doesn't need reasons to decline. They decline almost everything. They only take the cases they want to. And I'm sure the state Supreme Court is also discretionary, but I thought they should have reviewed at it because there was so much there. Yeah. I think it was error. The error was reversible without having to bring in 3 weeks of prejudicial character evidence for each. Yeah, I was a little disappointed in the Court of Appeals, but not as disappointed as I was in the Crumbly case with the parents. Dude, man, that appellate court, man, Lord. Crumbly, the son, was a school shooter, went to school, killed some people. There was some interaction with the parents. They've charged the parents with manslaughter, and the state appellate court, in saying the charge could be brought forward, said not only was it foreseeable that their son would shoot up a school someday, but they also said that a reasonable jury could conclude the parents could have reasonably foreseen the child would shoot up the school on that particular day. And that seems like a whole lot of foresight. That seems like a lot of foresight to me. I'm not sure how a reasonable jury can find that they had that level of foresight. That's a lot, you know? So I was like, okay, I don't know about that. And then, of course, I guess even more critical, we were critical of the Georgia Supreme Court today, which unanimously decided that double jeopardy ain't that much of a big deal. And we're like, what the hell are you doing, Georgia Supreme Court? What the hell's going on? So we frequently chastise courts of appeal. Sometimes they don't make sense either. Sometimes they say, as they did in California, the Court of Appeals said that bees are fish. So sometimes we're a little critical of some of the decisions of some of the courts that are out there. That's cool. Yeah. All right, I'm going to sign off for now. I hope you've had a fun time. I've had a fun time as well. And I really appreciate you all spending the time with me. I've been Uncivil Law, and until later, my friends, I hope you have the most fantastic of days. Good evening, my friends, and until next time, good night.